Well, everybody, and welcome to Pod TV's Supreme Court Review. I'm Nick Palavita. I'll be your moderator today. And today, of course, we have a very special guest who's going to be doing the heavy lifting. She's the former dean of the Washburn University School of Law and current professor of law at the University of Oklahoma School of Law. So let's bring in the person with the most knowledge in this area, which is not me. It's Professor Carla Pratt. Professor Carla Pratt, welcome to the Supreme Court Review. And I'm glad you're here because you're going to be doing all the heavy lifting, especially it relates to the Supreme Court cases. And apparently the court's been, once again, very active in terms of what they're doing. And, there's just a lot of cases before that. So we'll start going through them in progression. The first one I'd like you to take a look at, something we've discussed on the Pod TV network, is the famous case Biden versus Nebraska. Now, I know you're from Oklahoma. This is versus Nebraska, so you shouldn't have a problem with this one, if that makes any sense. Okay, what happened in Biden versus Nebraska?
So this is the student loan case. So President Biden issued a directive as the executive branch of government that would grant a waiver or debt relief to student loan holders, and this is significant because it's tens of thousands of dollars, $10,000 to $20,000 per debt holder for federally guaranteed student loans. And the plaintiffs here are saying that one, the president doesn't have the authority to do this because the president says that he was acting pursuant to the emergency created by COVID, and that the forbearance for student loans had expired. And so this was necessary to prevent significant defaults in student loans, which would harm the economy nationwide. But the states that are bringing the action here, Nebraska and Missouri, for example, are saying, no, you don't have the authority as the executive branch of government to interfere with these contractual arrangements and grant these basically wiping away student loan debt. And so the interesting thing here is that during oral arguments, there was a discussion about MOHELA, which is the Missouri Higher Education Loan Association that has huge contracts servicing federal financial aid for the government, the federal government. And interestingly, Missouri is suing, the state is suing, but MOHELA is not suing. And so the justices asked during oral argument, why isn't MOHELA here? Where is MOHELA? Do we even have state action here? And, does Missouri have the right to sue on behalf of MOHELA, which is a separate legal entity from the state? And so Missouri, of course, claims that it does have standing to sue on behalf of MOHELA. They didn't really answer why MOHELA wasn't there, why MOHELA isn't in the case. But I suspect that MOHELA wants to continue to get, these government contracts to service these federal student loans, and that they have no interest in suing the federal government. And so that's why they didn't bring the suit. So this one could very well be dismissed on standing grounds or lack of state action grounds, because MOHELA arguably is not a state actor, because any claim against MOHELA would not invade the state coffers. So they are not an arm of the state. They are a separate legal entity. But they do have some obligation to provide scholarships for the benefit of students in Missouri. And so Missouri is arguing that it's going to be hurt because MOHELA won't have the ability to provide those scholarships because they'll have less money.
Yeah. When I was reading through that, the thing is, I was thinking this could be bounced because of standing. And that means, well, the real question is, what does it mean? Does that mean that does Joe Biden then get to dismiss the student debt because it got bounced by standing, or does it go back, or can they decide? It looks like they had two issues there. He could decide the student loan issues separately from standing. What are your thoughts on that? I think it's bounced by standing. Reese.
So I think there is this question, if they have standing to challenge, the states have standing to challenge this executive action, it would be because of the, I would say, tangential harm to the states. So the states have proffered some harm, even though it is slight. And so if the court finds that they do have standing, the states are clearly state actors, and it would be interesting to see. But I think that there's a serious question whether President Biden had the authority here to act under this emergency action due to COVID, when the action was taken after the vaccine was already available, and the COVID emergency, if you will, was arguably already ended. And so I'm not really sure if they decide to hear the case. I think that is the sticking point for the government.
Yeah, I think that's a good thing to follow. For people who don't know what standing is, if John and Joe get into a fight, Peter can't come in and sue somebody. So, I mean,
you have to have injury in fact as the party that you've suffered.
So anyway, that'll be a very interesting thing to watch. See how they're going to decide that. Now we have another case. This is pretty good. 303 Creative LLC versus Atlantis. Tell us a little bit about that case.
Yeah, this one is very interesting as well, because it pits constitutional rights against one another. So Colorado has a public accommodation law, much like our public accommodation law that we got from the Civil Rights Act of 1964, that prohibits discrimination in the provision of services to members of the public. So if you run a business and that is open to the public, you cannot discriminate on the basis of race, gender, sexual orientation, religion, and the like. And so Lori Smith runs a website design company, and she is a Christian woman who says that she's not just a tech person, she's an artist, that what she does is artistic work and it's freedom of expression for her, and that she should not be forced by the government of Colorado to provide website design services for gay couples, because she religiously does not believe that that's sanctioned under her faith. And so she does not want to be forced to provide these website design services for gay weddings. And so this is really interesting because the question that Justice Jackson asked at oral argument was, well, wait a minute. What if someone wants to take old-fashioned photos from the 1940s and 50s, and they show up at the mall as a photographer, but they say, well, the 1950s were racially segregated, so I'm only going to take the photos of people who are white, because this is my artistic expression. Do they have the right to discriminate against Black families that want their photos taken? And so, this isn't just about religious freedom. It's also about the civil rights of marginalized and minoritized populations to have the dignity to have services in public accommodations. And so it's going to be really interesting, because we've seen that this is a very friendly religious rights court. And so, when I was thinking about this, my daughter Peyton is getting married at the end of the month, and she's African American, and she's marrying a white guy. And I thought, gee, every vendor just about that we've interacted with could say that they are an artist, right? The wedding planner does not only logistics, but wedding design. The florist does not only, sell you flowers, but they do the arranging of those flowers and the placement of those flowers and the presentation of those flowers. The DJ doesn't just play, songs. The DJ, does mixing and presentation of those songs. And so, everyone who's involved in this could say that they are presenting an art form. And so it's really that artistic nature that the court is looking at and saying that art is protected by the First Amendment. And so this could have serious ramifications for a lot of businesses in the marketplace that could say that they too are providing some artistic service.
It's like baking a cake, but now it's a website, right?
Yes. So this is a follow-up to the Masterpiece Cake Shop case in 2018. And this really puts the justices, in this case, it presents the issue that they skirted in Masterpiece. And so we'll see what they decide here.
Yeah, I think that'll be a great one to follow. And then this one was the most unusual case that I've seen, is the National Pork Producers Council versus Ross. Can you tell us a little bit about this case?
Yeah, so this one is very interesting because, states have police power to regulate things within their state, including not only human welfare, but animal welfare. And just about every state that I'm aware of has animal welfare laws on the books. California decided to adopt a law saying that the pens that hold pigs that are going to be raised for pork consumption have to be a minimum size so that the animal can turn around. And we have these big CAFOs, these big farms that produce pork where the pigs are in these chutes, if you will, and they can't turn around. And so California sees this as an inhumane way of raising pigs for the purpose of food production. And so they have regulated that if you're going to sell the pork in California, it has to be raised in a humane way and have these minimum size pens. The problem is that California consumes 13% of the nation's pork because it's, a very populous and a large state, but they produce only 1%. And so most of this law is going to, the burden is going to be on out-of-state producers of pork. So the question is, has California overreached in the exercise of its police powers and violated the negative implications of the Commerce Clause, what we call the Dormant Commerce Clause, by impacting interstate commerce and putting a burden on interstate commerce so that out-of-state producers of pork are not going to be able to sell their pork in California unless they conform their production to California's mandates.
Mm-hmm. Yeah, I don't think they've got to the chicken farms in North Carolina yet, but the chickens are really squeezed for space.
Chickens will be next.
I'm afraid so. When I looked at that case, I said, okay, you want 24 feet for the pigs. How many square feet do you need for the chickens? And then can't all the states start adopting rules like that, just destroying interstate commerce completely?
Nick, you've hit the nail on the head, because that is exactly the problem. If we have every state having different regulation here, we've had this checkerboard of laws that producers would have to comply with, which would just be insane. There is no congressional regulation on this, though. And so it's a space where, USDA is probably going to encourage Congress to set a national standard. But California is saying, given that the federal government has not preempted this space, that it can exercise its police powers and legislate here. It's also saying that not only is this about animal welfare, but that it's also about human health, because if animals have more space, there's less opportunity to transfer disease between the animals, and it's a healthier environment for producing food.
Okay, no more trichinosis then. Okay, that sounds
But
good.
I don't want my bacon prices to go up.
You can get your bacon, but not in California. All right, so we have another case that came out, and there were two of them together: Student for Fair Admissions versus Harvard, and of course we have Student for Fair Admissions versus UNC right here in UNC Chapel Hill. Tell us about those particular cases. What do we have here?
Yeah, so Students for Fair Admission is an organization whose members were denied admission to their higher education institution of choice. And their claim is that they were denied admission on the basis of race. And they claim that because both Harvard and UNC use race conscious affirmative action in their admissions process. And so the interesting thing about affirmative action cases that I've always found interesting, right? If you know anything about higher education admissions, right? They're the people who are admitted, and then there's this long wait list that can be over 100 people. It can be hundreds of people who are waitlisted. And then there are the people who are denied. And so all of these affirmative action cases is standing even though the plaintiff doesn't have to show actual injury. So the plaintiff doesn't have to show that I would have been admitted but for this race-conscious affirmative action. If you're denied, you are probably several hundred people deep on the wait list. And, it always just surprises me that the court doesn't talk about this issue of whether they would have gotten in but for race-conscious affirmative action. So the court skips over the standing issue, but Justice Jackson raised the standing issue at oral argument in the North Carolina case. She was not allowed to participate, or she recused herself, I should say, from participation in the Harvard case because she sits on the board, and that would be a conflict of interest. But while Harvard is a private entity, it is still subject to a federal statute that prohibits it from discriminating on the basis of race. And so the case against Harvard is brought under Title VI, that federal statute that's part of the Civil Rights Act of 1964. And the North Carolina case is brought pursuant to the Equal Protection Clause of the U.S. Constitution. But both claims are essentially the same, which is that race-conscious admissions unfairly discriminates on the basis of race. And the interesting thing here is that the plaintiffs are Asian Americans who were arguably displaced at Harvard because Harvard, if you just took the numbers, Harvard would have more Asian students admitted to Harvard College than white students because you're just looking at the raw numbers. But Harvard says we don't look at just raw numbers, we do holistic admissions. We look at the whole person. The problem from Students for Fair Admission says, well, but you don't have to consider race. You can consider a whole bunch of other things to get diversity, right? And so you could consider socioeconomic status, you could consider people's talents and their gifts and challenges they've overcome. You could consider all of that. Why do you need to consider race? And so this really puts to Harvard and UNC why they have to consider race, because we know after Fisher 1 and 2, you can only resort to the consideration of race in admissions if it's necessary to achieve the educational benefits that are derived from diversity. And so both of these cases basically, are putting to the court that these higher education institutions do not need to consider race in order to derive the educational benefits from diversity. They can get the diversity and the educational benefits from diversity through race-conscious means. And the Students for Fair Admission lawyers point to, schools in California and Michigan, for example, where race-conscious affirmative action is no longer permitted because the states have adopted laws banning consideration of race. And they say those schools seem to be doing just fine without the consideration of race. And so I think most of us agree that this could be the demise of race-conscious affirmative action in higher education.
Okay. And then we have another case as we head back west that they don't hear much about is Holland versus Bracken, wherever else you pronounce it. Tell us what's going on in this case.
Yeah, so this is the Indian Child Welfare Act case. The Indian Child Welfare Act was adopted in the 1970s because Indian children had suffered a long history of being removed from their Indian families and taken into white families. And so there had been this serious, significant loss of children that tribes had suffered. And this went all the way back to Indian boarding schools with Richard Henry Pratt, no relation to me, starting the first Indian boarding school in Carlisle, Pennsylvania. And initially, children were enrolled in the school voluntarily, but it evolved into a very vicious program where children were removed from the reservation involuntarily and sent to these boarding schools. This happened both here in the US and Canada. And they were sent against their will. They were not allowed to speak their tribal language. They were not allowed to wear their tribal attire. They were not allowed to practice their tribal faith. And so this was a project of forced assimilation, and tribes lost thousands of their Indian children through the Indian boarding schools, because once they were assimilated into the dominant culture, they did not return home to their tribe. They had, many of them lost their tribal language. They had lost fluency. They had lost that connection. And so then you fast forward after the boarding school era, we had an era where Indian children were being removed from the home, primarily due to circumstances associated with poverty of Indian families. And they were being placed with white families and adopted out to white families. And so tribes were losing their children through the child welfare system. And so Congress, in order to respond to this, adopts the Indian Child Welfare Act. The Indian Child Welfare Act requires states to respect tribal sovereignty and respect the tribe's relationship with its children. Because if you can't protect your children as a tribe, you have no sovereignty in the future, right? You will disappear. And so the tribes here have all nationwide, I don't know a single tribe that has not opposed this litigation seeking to declare the Indian Child Welfare Act unconstitutional. So there are non-Indian families who want to adopt Indian children, and states like Texas that want to see the Indian Child Welfare Act declared unconstitutional as racial discrimination in violation of the Substantive Due Process Clause and the Equal Protection Guarantee in the Fifth Amendment. The problem with that is, ICWA's been working just fine since the 70s. It requires that any Indian child that's placed in the foster care system preferably be placed in kinship care, someone who's related to that child. If a kinship care situation is not available, then the next alternative is to place the child with a family in that tribe to maintain that tribal connection. If a family in that tribe is not available, then the next alternative is to place the child with an Indian family in another tribe. And then if an Indian family in another tribe is not available, then to resort to a non-Indian family as the opportunity of last resort. And to try to provide services to the Indian family so that they can get that child back, and we can restore the family and keep that family intact and keep that family's connection with their tribe. And so the purposes of ICWA are very good in trying to ameliorate the cultural genocide that had been effectuated on Indian tribes and Indian children.
Mm-hmm. So you have a system that works, so let's go ahead and break it. Sounds like. Well, speaking of breaking another system, another case, Groff versus DeJoy. I don't work for the U.S. Postal System, and I have my own opinions about Amazon, but let's hear about this particular story. This is pretty good.
Yeah, so, this involves a gentleman who works for the U.S. Postal Service, who is Christian and wants to respect the Sabbath and not work on Sundays. And the U.S. Postal Service, typically didn't deliver mail on Sundays. So this used to not be an issue until they got these contracts with Amazon and they started delivering packages on Sunday. Many of us have probably received one of those packages on Sunday, or at least seen the trucks out on Sunday and said, hey, what's the mail truck doing out on Sunday? Well, the mail trucks now deliver on Sunday. And so this gentleman asked to be exempted from working on Sunday. He said that he's willing to work additional shifts Monday through Saturday, and his request is that he not be assigned to work on Sunday. And initially, it looks like the U.S. Post Office tried to accommodate his request, but ultimately they said that the burden was on him to find someone to cover his shift on Sundays. And he wasn't always able to do that, and he wouldn't show up to work on Sunday, and so they terminated him. And so the question here, another religious freedom case, is whether the standard that the lower court applied is the appropriate standard, because the Supreme Court in the past has said that unless it imposes an undue burden on the employer should provide an accommodation so that an employee can practice their faith. But a subsequent case came and said that employers only had to provide, de minimis changes. And so it lowered this standard and made it more difficult for an employee to get that accommodation. So really, the question is whether the court is going to restore and heighten that bar for when the employer can take negative action against someone for practicing their religious faith. And I suspect that they will heighten that bar and make it difficult for an employer to terminate someone.
And it went all the way to the Supreme Court, and we're waiting a decision. Unbelievable. Yes. But we have another case that seems to be really important, and this is the Arizona versus the Navajo Nation case. Water everywhere, but maybe not out west. What do we have for that case?
Yeah, so this year they seem to have a good water year, but for a long time, Arizona has been suffering a drought, and the Navajo Nation is partially in Arizona and has a treaty with the United States government whereby they were guaranteed all the water necessary to maintain them as a people on the reservation. Water is life, and so it's very smart for the tribe to seek this back in 1868. And so the tribe got that right secured in the treaty. And the question now becomes whether the federal government can, make some changes to water rights that arguably impact the tribe with respect to the Colorado River. And a couple of things here. Not only do we have the treaty, but we also have the notion that the federal government has this trust obligation, this fiduciary obligation to the Navajo Nation, because the Navajo Nation is, one of the 574 federally recognized tribes that gave up many of their rights and their lands in exchange for, positive, healthy relations with the federal government. And one of those promises that the federal government made was that they would have enough water to sustain themselves. But the question is, what does that mean, right? So does it mean that they have enough water? What is enough, right? Is it just enough to drink? Is it enough to drink and bathe? Is it enough to drink and bathe and water your lawn? Like, what is enough? Is it enough to farm and grow crops on the Navajo Nation? And so water has become the new gold in this region of the country. And so this is going to be a really important decision, not only for the Navajo Nation, but for those states surrounding as well.
Yeah, and the Navajo Nation is huge out west, big land still there. And the last case that we're going to have on our list, of course, is Lac du Fangou, Chippewa Indians, etc., versus Coughlin. Tell us what's going on in this case.
Yeah, so this case, unfortunately, the tribe operated a payday loan business and, made a loan to a tribal citizen who subsequently filed for bankruptcy and wanted that loan to be wiped away in bankruptcy. And the tribe said, no, the bankruptcy code doesn't apply to us because we have sovereign immunity. We are a quasi-sovereign. And unless the Congress has explicitly abrogated our sovereign immunity, this congressional statute doesn't apply to us. And so the question here is whether that the bankruptcy code does abrogate the tribe's sovereign immunity such that this recipient of the loan can have the tribal loan wiped away in bankruptcy with other debt. This is interesting because tribal sovereignty is a huge issue for tribes, and so this will have possibly ramifications outside of the bankruptcy context. But my hope is that the tribe will decide this the court will decide this very narrowly so that the tribe, so that tribal sovereignty isn't at risk or weakened in any way, and that this case hopefully will only be precedent for bankruptcy context.
Mm-hmm. Yeah, and it seems to me that they're still chasing this person for the debt, even though the person filed bankruptcy, which you can do on student loans also, which is a subject of a whole other conversation.
Yes, student loans
are not dischargeable in bankruptcy.
Are not dischargeable. That's
Make
right.
sure you tell your students before they get into heavy debt. But anyway, we'd like to thank you, Professor Carla Pratt from the University of Oklahoma School of Law, and also want to thank our viewers, not just in the United States, but around the world who watch the Supreme Court Review. And we're going to have more updates as they come out. But thank you for coming. Great job, and we'll see you next time on the Supreme Court Review. Take care. Bye-bye.
Thanks for having me.